might ask your court to look it up. We don't have it in our system at the AG's office because the shelter was just Thursday. I couldn't find it.
Okay, everybody can hear you now. And when they say which jail, there's your list of jails. Everybody can see and hear you now.
All right, I got it, my friend. Okay. All right. We all ready in the jail?
Yes, main jail is ready, Judge.
Okay. Appoint the public defender to represent those appearing before the court today. Linda Pantano.
Good morning, Your Honor.
Good
AJ
morning.
Amoroso on behalf of Linda Pantano.
Good timing. Okay. The court finds probable cause. Counsel, you wish to advise the court of something?
Judge, the state advised me that Ms. Pantano has absolutely no priors. It's a single strike battery between husband and wife, soon to be husband, separated.
They're separated?
Yes, then live separately.
And, wait a minute, this is the one where he came over to the house
She went
and,
to the house.
and then he came into the house and the argument, whatever occurred.
Correct.
Okay, what are you requesting, counsel?
Judge, she has no priors. I'm asking for standard pretrial release where all she needs to do is call in 2 times a week.
Okay,
Obviously,
the
no
court,
contact with the victim and no return to the address where the incident took place without a civilian assist from law enforcement.
well, she doesn't live there.
Correct.
No, she lives there, doesn't she?
No.
I thought it was the opposite. Let me just,
It's his residence, Your Honor, and the defendant pulls up.
and they were exchanging the children.
So Judge, as far as the no contact, the victim is Timothy Bly. And as far as the residence where if she's going to return, she needs a return with law enforcement, that would be 4220 Northwest 62nd
Okay, I got you.
Court.
The way this reads, I thought it was her residence and because it said he arrived.
Correct.
But
Okay.
he arrived at his residence.
Huh?
He arrived at his residence.
They both arrived there, that's, yeah.
Correct.
Okay, the court will order the defendant to pretrial release. There'll be no contact with the alleged victim, ex-husband. The court will allow visitation if by the children with both of the parties. If and if she has any personal effects there, she will take a police officer to remove same. The children may be exchanged by the mother dropping, how old are the children?
Judge, there's only, Linda, I want to make sure I'm correct on this. There's only one child still between them. The other one is in college, correct?
But how old?
16.
Okay. That she may drop them off but must stay in the car and the child goes in and out on his own.
Perfect.
Okay, thank you very much.
Thank you,
Judge,
sir.
Judge, for the record, you're making a probable cause finding.
Yes, I found PC. Yep, okay.
Thank you, Your Honor. Enjoy the rest of your weekend. Linda, you'll be out soon.
Christina Mims.
Good morning, Judge. Assistant Public Defender Paul Lipoff.
Okay, the court finds probable cause, charges domestic battery. There'll be no contact. Any firearms will be surrendered. Bond is set in the amount of $500. Ma'am, are you working?
No, not right now.
Excuse me?
Not right now.
Okay. Any prior state?
Judge, no priors.
Okay. Pretrial release.
Thank you, Judge.
Thank you.
Judge,
Joanne?
I'm asking for a photo order. From my understanding, Ms. Mims had some sort of injury. I'm told by my co-counsel.
Okay.
Judge, just to be clear, that was a finding of probable cause. Did you maintain the $500 or did
No, pretrial release.
ROR pretrial release?
ROR pretrial release. Joanne Rozier,
Yes.
Paul Ryan. Okay. You're charged with domestic battery. I find probable cause. Any prior state?
No priors, no arrests, Judge.
And Your
Okay.
Honor, I spoke to Miss Royster this morning. She's lived in South Florida her entire life. She has all her family down here. Currently, she's a student at Florida Career College.
I'm going to put her on pretrial release. Okay. No contact. Any weapons must be surrendered. Won't come in 500 feet of the party. Monica Matthews.
Yes, sir, Your Honor.
You're charged with, hang on, I'll get him over to you. It's a long reach here. Okay, Monica Matthews, you're charged with battery, and possession of a controlled substance without a prescription. I find probable cause. Any priors?
Yes, Judge. In 2015, she was convicted for dealing in stolen property, 2 counts of dealing in stolen property, 2 counts.
Okay, court, on count one, $500 bond, on count two is $1,000 bond. There'll be no contact with the alleged victim. Any weapons be surrendered. Dana Rondina,
Yes, Your Honor.
you're charged with battery, domestic violence. I find probable cause. There's a violation of probation with a no bond hold. When is she scheduled?
The 20th.
August 20th. Court finds probable cause. You'll be detained going before Judge Cohen, and it's a $1,000 bond on count one.
And Judge,
On,
I'm sorry, Judge. I'm just hearing from
excuse me?
The victim has safety concerns in regards to the defendant, Your Honor.
And Your Honor, from my review of Ms. Rondina's criminal history, she does have a 2017 felony battery. She was put on 4 years probation. The same victim in that case was the same victim in this case.
Okay, and there's a no bond hold.
Correct, in violation of probation, Judge. I just didn't know if you
Yeah,
wanted
that's
to-
Judge Cohen, okay? And he's head of the he's head of the domestic violence unit, right?
Right.
So the case will go to him,
Yes, Judge.
okay? All right, on Petra Castro?
Yes.
You, Miss Castro?
Yes, ma'am. Yes, sir.
Okay, charged with aggravated assault with intent to commit a felony and aggravated battery. I find probable cause. Bond is set in the amount of $2,500 each count, total of $5,000. No contact. Any firearms must be surrendered.
Your Honor, I spoke to Ms. Castro this morning. I do not believe she's going to be able to afford the bond as set. She's lived in South Florida her whole life. She does have family down here, and she owns her own house. The only income she has is she's received disability for the last 5 years due to neurological issues, and the check she gets every month is $750 from the state. I would ask Your Honor if you would set it maybe $750 per count. I believe that would get it more in her range, but set it $5,000 in total. I believe that's about 6 months worth of disability checks that she receives.
Counsel, go ahead. State.
Judge, I would be objecting. This particular, Ms. Castro has a 2017 ag assault.
Okay.
That was dropped, but it is a,
I'm gonna leave them at 2,500 each. We had a knife, then we had a board. Okay. Have a good day, ma'am. You, Harishnish?
Yes, Judge, main jail.
You're charged with domestic violence. I find probable cause. No contact with the alleged victim. 500, can't come within 500 feet of the victim. And bond is set in the amount of $1,000.
And Judge, if I could also add additionally, the victim has expressed safety concerns in this case. And I would also like to point out to your Honor's attention that there is a 3-year-old daughter and a 2-year-old son that was present, that in the officer's presence was repeating what they observed. So I would actually be requesting a $5,000 bond.
Okay.
Judge, this is the first offense that Mr. Harrison has had. He is living elsewhere and he has no prior criminal history.
All right, I'm going to leave the bond at $1,500. I'm going to, sir, you can have no contact. You can't go to their residence. You can't call them, speak with them, have any direct or indirect contact with them until further order of the court. Do you understand that?
Yes, sir. It's okay.
Okay, and if you have any firearms, you must surrender them to the local police agency. Have a good day. Ian Sykes.
Thank you, Judge. Okay, have a seat for me.
Mr. Sykes, you're charged with domestic violence. I find probable cause. Bond is set in the amount of $1,000. There'll be no contact with the alleged victim. Any firearms must be surrendered. Stephen Paul. Mr. Paul, you're charged with a violation of a restraining order. You have a no bond hold, and you have 3 traffic offenses for which bonds are not required. Court enters a no contact order. State,
Yes, Judge.
on this one, is there any recommendation?
Sorry, Judge, I can have one more.
This is a violation of a domestic with a firearm.
It is, Judge. Those charges were unfiled back in May.
In May, the filed charges were unfiled.
Yes, Judge.
Well, as of right now, Judge, it looks like
It was converted to a misdemeanor. Aaron passing on behalf of the state. He's charged with carrying concealed weapon and credit card, being in possession of stolen credit cards.
I would also like to point out, Judge, that in 2018, there was a felony battery domestic strangulation that was null pros and a false imprisonment that was null.
All right, but those are the other charges, right? Another case.
Correct.
Correct.
What's he got pending?
The pending right now, Judge, is a misdemeanor possession of stolen credit card and open carrying of a weapon.
Okay.
And in this case, obviously, we have an issue of a weapon in this particular case as well, Judge. I'd be asking for a $5,000 bond, no victim contact.
But there is a injunction that he violated.
It's,
The case is dropped.
Huh?
The case is dropped. The domestic been dropped since May 24th of 2018.
Is that correct?
That's accurate, Judge.
Judge is accurate.
Okay. So is there any probable cause for
Judge, the state
the
would be
first count?
requesting- The state would be requesting 24 hours to perfect.
Counsel, you know, the problem is, I can't see you, I can't hear you.
Sorry, Your Honor.
Sorry, Judge. The state would be requesting 24 hours to perfect. The issue is whether or not in the domestic violence case, which was dropped in May, if that judge's findings were for no weapons, which typically they are. We can't find that,
But what I'm trying to say is, has the case been dropped?
It hasn't been dropped, it's been converted to this misdemeanor case, which is a.
No, it's not. The
possession of
misdemeanor
stolen
case.
Ma'am,
credit card
don't argue, you'll get a chance to speak.
And carrying a weapon, which is currently pending in front of Judge Brown.
And when was that referred over there?
May 22nd, 2018.
I can jump in? Judge, I'd ask for a minimal bond.
Okay. Court is setting bond in the amount of $1,000. No contact, no firearm, not come within 500 feet of the alleged victim. Have a good day. Zachary Foster. You're charged with battery, and domestic violence. Court finds probable cause. No contact, battery set, bond is set in the amount of $1,000.
Judge, Mr. Forster has absolutely no income and no money at all, and is not able to afford that bond.
Well, Judge, the state would be requesting a higher bond in this particular instance. Mr. Brewster has a 2013 dealing in stolen property, false ownership of identification to the pawn shop. He was sentenced to 2 years prison, a habitual offender. Additionally, he's got a
Habitual offender on what?
he was a habitual offender on the 2013 dealing in stolen and false ownership due to prior criminal history.
Okay. Bond is set in the amount of $1,000. Okay, Jermaine Ramsey. Yes, sir.
If I may, Your Honor, before you announce probable cause, I'd like to bring to the court's attention, let's deal with aggravated battery, or actually aggravated assault. There is no probable cause on that in the police report. There are 7 elements to aggravated assault. Probable cause affidavit is missing 1, 2, 3, and 4 of the jury instructions. Specifically, there's nothing in the 4 corners of the document that the defendant intentionally and unlawfully threatened by word of act any police officer, that at the time he allegedly did, number 1, that he appeared to have the ability to carry it out, that the act created in the mind of the police officer a well-founded fear that the violence was going to take place, and that the assault was made with a deadly weapon. The only thing that's sitting in the probable cause affidavit, Your Honor, is that police were called out for a misdemeanor domestic violence. That's all they know. The person was wearing white short and ripped jeans. When the police got there, he saw the defendant reaching into a vehicle. They asked him to show his hands, and he's walking towards them, and he's saying, "Are you going to shoot me?" Now, I don't know, I haven't spoken to my client on this, but clearly they must have their guns drawn too. Police, that's all he did. He's walking towards them, yelling, "Are you going to shoot me?" One police officer comes from the back, takes him down to the ground, and my client stiffened his arms. That's the resisting with violence, without violence rather. The alleged victim in this case, that police talked to her, she said that there was one strike. It was allegedly a punch to the face, but yet there was no marks, scratches, or anything on her face. She refused to give photographs. She refused to give a statement. In dealing with count 1 aggravated assault with a deadly weapon, it's a second-degree felony with a mandatory minimum of 3 years. There's nothing in the 4 corners of your document, and I'm asking you to ROR him on that charge. In regards to the domestic violence misdemeanor, I'm asking the court to do a $1,000 bond. No contact, direct or indirect, with the victim. They have a child in common together. And with the resisting without violence, the stiffening of the arms when he's down, been thrown down to the ground, I'm asking the court to ROR.
State?
Judge, there is a threat. The defendant is seen reaching into a vehicle and then approaching law enforcement officers as he's being instructed to show his hands. He's shouting. He kept walking up to the officer. He's screaming, "Are you going to shoot me, Your Honor?" That's the assault. His ability.
How is that an assault? Are you gonna shoot me? Are you gonna shoot me?
Well, Judge, I would say there's at least probable cause for the lesser included of a misdemeanor assault. But if Your Honor would be inclined,
Well, I mean, I understand that the officer, what you're saying is that the officer may have been threatened by him walking towards him. But,
I don't know if they're dealing with a person. I'm sorry.
So, Judge, I'd be requesting 48 hours to perfect the probable cause affidavit regarding the aggravated assault.
okay. Because I also note that when he was doing this, he was walking towards the officer, and there was no weapon involved, and basically the officer grabbed him from behind, took him down, and while he did not put his hands behind him, they didn't have any real problem placing him in cuffs.
He flexed his arms.
Yeah. And okay, the court finds the probable cause for count 1. The court finds no probable cause for count 2 and gives the state 48 hours to perfect. On the resisting without violence, the court finds probable cause. The court sets bonds in the amount of $1,000 on count one, $1,000 on count two, 500 on three.
Thank you, Your Honor.
Okay?
Judge, just to specify no.
And no contact with the three alleged victims.
So they can perfect, but it's worse to have bond on all three charges.
They can perfect, yes,
Okay, but he's allowed to be bonded out now.
but he may bond as it is.
Thank you, Your Honor.
Thank you. Then we've got Eric Juneau. State,
Yes, Judge, Mr. Juneau.
this is, I believe this is, needs to be transferred to mental health court.
Judge, I don't have any notice about mental health court transfer.
Well, let me put it this way. He supposedly went to this, ripped the cell phone out of her hand. When they made contact, he was in the backyard. He was rambling about being in a magnetic field. The static electricity was bothering him. He was having some sort of mental breakdown.
Well, Judge, I don't think that's the standard to have it transferred directly to mental health court. Typically, they would have to have a mental health evaluation in front of the circuit judge that they're assigned to. For purposes of today, a finding of probable cause and any sort of bond release conditions. He has a prior, well, he doesn't have any prior criminal history, Judge.
No priors on this? Okay. Does he have any place to live?
Yes, Judge, he does. And that is separate from the victim, alleged victim.
Actually, Judge, I'm sorry. This is a domestic violence case still. So there is a fleeing and eluding in 2003 that was null prost, and a resisting without violence that was null prost, and a 2003 reckless driving that was null prost.
What are you requesting for the battery on count one?
Judge, I would be, considering the circumstances in the entirety of the probable cause affidavit, I'd be requesting a $10,000 bond.
And Judge, $10,000 is absolutely unaffordable and would be tantamount to no bond for Mr. Junio.
Okay. Court at this time finds probable cause. Court sets bond on count one in the amount of $1,000. On count two, $1,000. On count three, $1,000. On count four, $1,000. And count five is $1,000. Total of $5,000.
And Judge, if we could, in the event that he posts bond, some sort of pretrial release and no victim contact.
I'm ordering no victim contact, and that's the extent of what I'm doing. Okay.
Your Honor, I'm asking for a photo order. His injuries are obvious.
Excuse me?
I'm asking for a photo order. He has injuries to his face.
Okay, granted. All right. Sydney Pantaleon.
Yes, no problem, John. We're gonna need a Spanish interpreter, please.
All right, put him on recall for Spanish interpreter. Oh, we have it? Oh, hi, how you doing?
Good morning, Your Honor. Spanish interpreter is present. Luz Angela Lopez, LPEZ, certified Spanish interpreter for the trial.
Okay, you're charged with false imprisonment of an adult under the age of 13 and tampering with evidence. I find probable cause. These are add charges. Is that correct, State?
Well, they're change of charge.
If the interpreter may.
They're a change of charge. What was the bond in the original charges?
Your Honor, the interpreter cannot interpret simultaneously due to the nature of the proceeding. So if the interpreter is allowed to interpret what Your Honor just said, please. Señor Pantaleón, el señor juez anuncia que a usted lo tienen detenido debido a que lo han acusado de privación de la libertad ilícitamente de un adulto o un menor de 13 años y de interferir con un caso de delito penal. Le pregunta a la fiscalía su opinión. Thank you, Your Honor.
Your Honor, originally, there was proof evident presumption great found on counts 6 and 7, which was originally a kidnapping and tampering in first degree. The bond was no bond, and there was no victim contact, maintaining 1 mile distance, and no possession of any firearms or ammunition.
Well, the no contact order remained in force effect, but we're now down to third-degree felonies, correct?
El señor abogado, el señor fiscal está hablando, señor juez. Originalmente la acusación que tenían en contra suya habían hallado que la prueba era evidente y la presunción de gran envergadura por una acusación de secuestro y un delito grave de primer grado. No podía pagar fianza para salir en libertad. Le habían ordenado que no tuviera contacto o comunicación con la víctima y que se mantuviera 1 milla alejado a todo momento.
Judge, what I'm showing is that the false imprisonment was a change of charge to a third degree, but the tampering is a first degree.
It's a first degree.
The tampering is a felony of the first degree?
Yes, Your Honor.
El señor fiscal está diciendo
Okay,
que
and what are you asking for bond on that tampering charge?
el señor fiscal le ha dicho al señor juez, la acusación se había enmendado a un delito menos grave de tercer grado. El señor juez pregunta, pero la acusación de interferir con un caso de delito grave es un delito menos grave de primer grado. Pregunta a la fiscalía que está pidiendo que le impongan de fianza para esa acusación de interferir en un caso de tercer grado.
Sorry, Judge, if I could just have 1 moment.
Pide a la fiscalía un momento.
I believe count 7 is tampering, it's a third degree felony, is how it's filed, because there's no longer a first degree felony that was committed.
El señor abogado defensor aquí presente, él habla.
Then, Judge, in
La séptima acusación es un delito grave de tercer grado.
Judge, the other bond amounts in this particular case are $25,000 on count 1, $25,000 on count 2, $25,000 on count 5. I would be asking for a $25,000 bond.
On what?
On counts 6 and 7 each.
Okay, count 6 is a third-degree felony, correct?
Yes, Judge.
Count 7 is a third-degree felony.
El señor fiscal pide al señor juez que le imponga una fianza de $25,000 para la primera
Is that correct?
acusación.
I think it's a first degree, Your Honor.
Look at the state instruction sheet that you guys filed, changed it to tampering with the witness.
Sorry, navigation is poor right now.
Perdón, señor, el señor fiscal continúa. Que le impongan una fianza de $25,000 para la primera acusación, $25,000 para la segunda acusación, $25,000 para la quinta acusación. Entonces, para la sexta y séptima acusaciones que le impongan $25,000, el señor juez pregunta, y estas acusaciones son delitos graves de tercer grado, así. El señor abogado defensor dice que el fiscal ha cambiado la acusación, esa acusación séptima, que es de interferir con los testigos en un caso.
Defense counsel is correct, Judge. They're both third degree felonies. I misspoke.
Okay.
El señor fiscal se
Bond is
corrige.
set in the amount of $1,000 on count 6, $1,000 on count 7. And there'll be no contact with the alleged victim. Okay, Kevin
Señor,
Crawford?
I am so sorry, Ana. El señor fiscal dice al señor juez, sí, señor juez, me corrijo. El señor abogado defensor, I'm so sorry, Ana, the interpreter is not finished interpreting for the prior defendant. If you
I'm
could
sorry.
come back, I'm sorry.
I'm sorry, go ahead.
Sí, señor, el señor abogado defensor, el señor fiscal pide que se disculpa, estaba equivocado, el señor abogado defensor tiene la razón. Ambos delitos 6 y 7 son delitos graves de tercer grado. El señor juez impone $1,000 de fianza para la sexta acusación, $1,000 de fianza para la séptima acusación. No debe tener contacto o comunicación con la supuesta víctima. Thank you, Anna.
Here, give them to me. Okay. Now we're on Kevin Crawford.
Yes, Judge, main jail.
Okay, Kevin Crawford, out-of-state hold. There's a no bond. You'll be detained going before the extradition court in North Carolina. Did somebody say something? Okay. You're detained going before the court
Thank you, Judge.
in reference to the extradition to North Carolina. Okay, then we have Christine Moore.
No problem, John.
Your Honor, this is a municipal ordinance case. I cannot represent her this morning, my office cannot, and I don't believe there's a city attorney here.
Okay. Christine Moore, you got bond the amount of $25. I find probable cause. It's trespassing. You want to plead no contest?
Yes.
Time served. Have a good day. No return.
I'm getting out today?
Have you got any, don't have anything else holding you? Yes. And wave. Okay. Carol Pugh, or
No
Powell.
problem.
Same situation for Ms. Powell, Your Honor. This is a municipal ordinance. My office cannot represent her.
Okay. You're charged with trespassing. I find probable cause. Bond is set in the amount of $100. Do you want to plead no contest?
No contest.
Okay. Time served. No return.
Thank you.
Kahira Smith.
No problem.
You're charged with, you have a capias, $500 bond. I find probable cause. The charge is possession of paraphernalia. You want to plead no contest?
Yes.
Time served.
Judge, this is a county case, Judge. They
This
would
is
have-
what?
This was a county case, Kiera Smith.
Yeah,
This would require a colloquy on this particular instance.
I can't hear you. You're talking to the ground.
Sorry, Judge. The defendant would have to be colloquied for a plea.
I'm hearing that. What are you saying?
The defendant would have to be colloquied, Judge, regarding the right to counsel, right to a jury trial, any immigration consequences.
Okay. Let me have Miss
Smith.
Smith back.
Judge, may I approach?
Yep. What do I need to do on this? Oh, okay. Ms. Smith?
Yes.
Okay, ma'am, you understand you have a right to have an attorney, you have a right to go to trial, you have a right to make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right to go to trial, cross-examine all the witnesses, call witnesses your own, and put on a defense. That by entering a plea, you'd be waiving those rights. If you're not a citizen of the United States, you'd be, this could be subject you to deportation proceedings. That warning does not apply to a citizen. Knowing that and understanding that, you want to plead no contest?
Yes.
Time served. Thank you. Samantha Hester.
These are medical research, Your Honor.
Okay. Ortez.
Main jail, Judge.
Okay. Ms. Ortez, you have 2 counts, and there is capias, is bond set the amount of $500 each. One is on the unlawful use of the name, and the other one is obstructing without violence. You want to plead no contest? You understand you have a right to go to trial, you have a right to have an attorney, you have a right to cross-examine all the witnesses, call witnesses your own, put on a defense, that if you enter this plea, you're waiving those rights. You also have a right to appeal any harmful error may be committed during the period of trial. And you also, if you're not a citizen of the United States, you could be subject to deportation proceedings, but those that warning does not apply to a citizen. Still want to plead no contest?
Yes, sir.
Time served.
Thank you, Judge.
Paula Rassel,
Medical reset.
Amy Butler,
Medical reset.
Bianca Bailey,
Medical reset.
Alicia Addison.
Main jail.
Okay. Miss Addison, you've got a violation of probation. It's a felony. There is a no bond hold. You'll be detained going before the Judge Bailey. August the 10th? 15th. Have a good day.
Thank you, Judge.
Frankie Hancock.
Medical reset.
We have an epidemic going on?
Pretty much, Your Honor.
Alicia Hill.
Medical reset.
Okay. Aliana Marnie.
Medical reset.
Montgomery.
Main jail, Judge.
Okay. Miss Montgomery, you're charged with, you had a writ of possession for $282. You need to pay $282 to be released. That's by Judge Gunderson. Then you have a violation of probation, a felony. There's a no bond hold. You'll be detained going before Judge Colra. Date?
On August 15th.
Okay. Have a good day, ma'am. Brittany Wilbur.
Medical loan, Judge.
Is that a reset?
Yes, Judge.
$25 years, never had that many reset. Wayne Golden.
Judge, this is an MO case, and our office cannot.
Yeah, I understand. Mr. Golden, you have a open container violation. Do you want to plead no contest?
Yes, sir.
Time served and waive.
Thank you, sir.
Have a good day. Ronaldo Ekbom?
He's in North
Ekbom, yes, good morning, Your Honor. North Brown, John.
Just so
North
your Honor
Broward?
knows, North Broward called me. One of the medical resets is actually there. So after Mr. Ekbom, if we can call, it was Miss Amy Butler on page 10.
Okay.
She's actually.
We're gonna, counsel, let's get this one and then we'll, okay.
So you know what they called me to say?
Ronald Ekbom, okay. Sir, you have, 3 capiases. Bonds are 500 and 100 and 100. So you've got $700 in bond. You have a petty theft, and then you have 2 city ordinances. You want to plead no contest?
Yes, sir.
You understand you
Yes,
have a
Your
right
Honor.
to have, you have a right to have a trial, you have a right to have an attorney, you have a right to cross-examine all the witnesses, call any witnesses that, and question any witnesses that you want. That if you're not a citizen of the United States, this is a criminal charge and it could be used to deport you. That does not apply if you are a citizen. The court, the what?
What case are you pulling this gentleman out to? Is it 2489?
This is, I've got 2 city ordinances, which are counts 2 and 3, and then I have the 1 misdemeanor, which is a petty theft. Okay?
2489.
And time served on count 1, time served on the other 2. On count 1, no return to the place where the theft occurred. Okay, on Eric Smith.
Main jail, Judge.
Eric Smith, you're charged with
What you did, you are me? Yeah. What?
Okay, Mr. Smith, it appears that you've got 2 capiases. The first one is a traffic offense, $25 bond. The second is a driving while license suspended. Since your driving while license suspended, if you pled it out, could lead to a habitualization, you probably do not want to plead that out.
Judge, I explained that to Mr. Smith. He does have a valid license at this time, so he does not.
So
want to
no,
plead
he
it
does
out.
not want to plead it out. Okay, the court, as to count one, dismiss, count two, ROR. Appear in
Thank you,
court,
Judge.
get it straightened out, sir. No, dismiss the infraction. Okay. Bernard McDonald.
Hit that button when you want to
You
talk.
got a municipal ordinance violation. You want to plead no contest?
Yes, sir.
Time served. Have a good day. James Cardell.
James. Fine, James.
You're charged with possession of drug paraphernalia, $100 bond. You have a capias on a municipal ordinance. Do you want to plead no contest?
That would be overstated objection, Your Honor. He has 2 or 3 pending felony cases.
Yes, he does wish
Wait
to
a-
plead no contest, Judge.
All right, wait a minute. Counsel, he has felony cases pending. This is going to add to his score.
And that's also a violation of pretrial release, Judge.
Well, if he's already arrested for it, it's the violation of pretrial release. If he pleads out, that doesn't change that, does it?
No, we just gotta go and get him again, pick him back up, and bring him back to jail.
No, you have to file the petition, don't you?
Yes, we do, Your Honor. We have to give him 3 hours notice.
Okay. Okay, if they've indicated that they're going to file a
Motion to revoke bond.
petition to revoke bond, the so I'm not going to offer him a plea on count one. On count two,
Judge, regarding the capias on count 2, Mr. Cordell indicated that he was in custody at the
right,
time.
I'm going to dismiss on 2. Count 1 remains the same. Count 1. Count 1 remains a $100 bond. Count 2 is it's a misdemeanor, it's a municipal ordinance, it's dismissed.
Thank you, Judge.
Thank you. Kefeth Wilson. You're charged, sir, with 3 capiases, $25, $500 and $500. Okay, 2 are, 1 is a misdemeanor, which is possession of drug paraphernalia. The other 2 are municipal ordinance violations. You want to plead no contest?
Yes, Judge.
On count 2, the possession of paraphernalia, you have a right to have a trial, you have a right to have an attorney, you have a right to make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right to cross-examine all the witnesses, call witnesses of your own, and if you're not a citizen of the United States, this being a criminal charge, you could be deported. That warning does not apply to a citizen. Court accepts a no contest plea. The court sentenced him time served, all counts.
Judge, Mr. Wilson understands and thanks the court.
Read the PC and that there's a factual basis.
Found probable cause, yes. Didn't I say that? I'm sorry.
For the pleas, we need that,
The plea, I understand.
and that there's a factual basis.
Okay. The court finds there's a factual basis to accept the plea. Okay, Daryl Fletcher. Okay, Mr. Fletcher, you're charged with possession of cannabis, less than 20 grams, $100 bond. Then you have two traffic violations. And both of them are for driving without a valid driver's license. Do you want to plead no contest?
Judge, he's represented by counsel on those other two cases.
Who's representing him?
Ian Muir.
Huh?
Ian Muir of the Public Defender's Office.
Oh, PD's
He has
okay.
3 pending cases open.
Your office supposedly represents him.
He has 3 pending cases open at Judge Carpenter.
Counsel, your
Yes,
office
Judge.
represents him. What do you want to do?
Yes, Judge, he would like to resolve the no valids.
You want to resolve them all?
No valids should not risk habitualizing him, and speaking with Mr. Fletcher, he would like to resolve them.
All right, would he like to resolve the other one too? Count one.
Yes, the possession as well, Judge.
Okay. Sir, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, up you got. Okay, do you understand, sir? You have a right to go to trial, make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You understand that?
Yes. Yes.
You understand that you have a right to have an attorney, and you do have an attorney, that the public defender's office is appointed to represent you. You understand that?
Yes.
That by entering a plea, you are waiving those rights.
Do you understand? Yes.
Okay, are you doing that freely and voluntarily? No one's making you do it.
Judge, the state has any evidence here. I know this gentleman has looked this out. There's been motions to appoint experts. In this case, the PD's office has reasonably.
I'm having trouble hearing.
Okay.
This gentleman and found him to possibly be a mental health concern or incompetency concern. They
What
filed a
division
motion.
is he assigned to?
He's assigned to Judge Carpenter Toys Division, which is MM.
Okay, well, that's not Judge Wren's division.
That is not Judge Wren's division. He's in the middle of having his two or three evaluations before a court can determine and have a
Okay.
hearing whether or not.
All right, okay,
And Judge,
okay.
if
Thank
that
you,
is the
thank
case,
you,
and
State. Huh?
If that is the case, I would ask Your Honor for ROR. If he is found incompetent, we'd be moving for ROR anyways.
Okay. First off, I cannot entertain a plea because of the indication that evaluations are being conducted. Okay?
Understood, Judge.
So number two, I'm going, as to all of these counts, no plea can be taken. The court notes that the defendant is represented by the Public Defender's Office. The court will ROR the gentleman on,
Judge, that would
all
be the
counts.
state's objection. He's refused to.
Your objection's noted for the record,
Thank you, Your Honor.
Thank you, Judge.
all three. By the way, State, thank you for pointing that out with the, would not want to have taken that plea.
Judge, I need the gentleman look familiar. I currently had 8 or 9 months in that division. The risk concern is that he doesn't come to court, and I don't think he's having contact with his attorney.
Well, I understand your concerns, counsel, but I believe they've got the gentleman's attention, and let's see what happens.
And Judge, I will also speak with the public defender in Judge Carpenter Toy's room and make sure that he reaches out as well.
It's Mr. Muir.
Lawrence Jones. You
Yes,
Mr.
Mr.
Jones? Okay. Mr. Jones, you're charged with trespassing, fine probable cause, bond set in the amount of $25. This is a municipal ordinance, I believe.
No, his charge is
It's a state statute?
yes, sir.
Okay. It's a state statute. Do you want to plead no contest?
Yes, sir.
Raise your right hand. Swear to tell the right. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. Okay, do you understand, sir? You have a right to go to trial, make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right when you go to trial to cross-examine the witness, call a witness your own, put on a defense that by entering a plea, you're waiving those rights. Are you under the influence of alcohol or drugs at this time?
No.
Ever been adjudicated incompetent?
What does that mean?
Have you ever been?
Okay. And do you understand, sir, if you're not a citizen of the United States, this is a criminal charge and you could be deported. That warning does not apply to a citizen. You want to plead no contest?
Yes, sir.
The court, knowing and understanding the court finds probable cause and a factual basis to accept the plea, the court accepts the plea as freely and voluntarily given to court, sentence him to time served.
Judge, you want to plea out his other case as well? He has a pending case in front of Judge Hurley, which is also a state-charged misdemeanor in the second degree for trespass.
You wanted,
I can give Your Honor the case number now. It's not on the docket. He is not being held on that either.
well, we can plead it out. What's the number, counsel?
1-800-147-5 MM20A, and it's at North Satellite in Deerfield Beach.
Oh, God.
It's in front of Judge Hurley.
And the charges?
The charge is Florida
Trespass.
Statute 810.08, subsection 1, 2A. And it's charged as a second-degree misdemeanor, trespass of a structure.
Okay.
You want to plead no contest on that one also, sir? You understand you're waiving all the same rights? Court finds there's a factual basis to accept the plea. Court sentence the defendant to time served.
Thank you.
Thank you, Judge.
Okay. On Frederick Crawford,
No problem, Your Honor.
Mr. Crawford, you're charged with failed to obey a police officer, no bond required, resisting without violence, $100 bond, and false ID to the officer, no bond required. Do you wish bond, the total bond is $100. Court finds probable cause. Do you want to plead no contest?
Yes, sir.
Judge, to your priors, the state would be seeking a jail sentence in regard to this, if I may pull up his priors for Your Honor.
For what, on which charge? Excuse me?
We can run them all consecutive.
What are you seeking?
Just opened up about a week.
He was arrested in Miami-Dade on July 30th for loitering and prowling. Those counts were dropped. He was adjudicated guilty on February 22nd, 2018 in Miami-Dade for trespass of property after warning and resisting an officer without violence. He was adjudicated guilty for a trespass.
Okay, I understand that. What do you said I want jail time. He's already been in jail, so how much more time do you want?
On count 2, the state would be requesting 15 days.
On count 2,
On count 2, Your Honor.
you want 15 days
Yes, sir.
additional.
Yes, sir.
Okay. Mr. Crawford? Can you hear me?
Yes, sir. Yes, sir.
State wants 15 days additional time. That would be 15 days for, plus credit for whatever time you serve. That's their recommendation. You can plead open to the court, okay? And then it's up to me what the sentence would be. But it could be as much as 15 days, or it could even be more. It could be a lot less. It depends upon what the court position is, if you plead open. Do you want to plead open, or do you want to
Yes,
go to
sir.
court? What?
I want to plead open.
Okay, court at this time. Sir, do you understand you have a right to go to trial? Make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right when you go to trial to cross-examine all the witnesses, call witnesses of your own, and put on a defense. That by entering this plea, you're waiving those rights.
Yes, sir.
And you understand if you're not a citizen of the United States, you could be subject to deportation proceeding, but that doesn't apply to a citizen. Understand?
Yes, sir.
Court
Yes,
at this
sir.
time accepts the no contest plea, finds they're freely and voluntarily given defendant knowing waiving rights. The court finds his factual basis to accept the plea. On count 1, time served. Count 2, 5 days in the Broward County Jail, credit for any time served. Count 3, 5 days in the Broward County Jail, credit for any time served. On Wilmont Brown.
Main jail judge.
Wilmont Brown, you're charged with criminal mischief. I find probable cause, bond is set in the amount of $25. Okay, Mr. Wilmont, can you make the $25?
No. Judge, he's not able to pay the $25, and as Your Honor knows, a bondsman's not going to do the work for a $25 bond.
Well, I don't understand that. The problem is we got the issue of the damage to the 7-Eleven. How long have you resided in Broward County?
How long? About 10 years, Judge.
Any priors?
Do you have any priors? No. Mr. Brown indicates none.
Huh?
Yes, Judge, one moment. He was adjudicated guilty of a municipal ordinance just a few months ago in front of Judge Levy for disorderly conduct resisting without violence. He had a involuntary placement back in 2015. In 2010, I can't read that.
Okay, this
I can't read that particular.
this looks like a Judge Wren court.
Yes, sir. It does.
Okay. Court at this time leaves the bond at $25. How do we get it over to Judge Wren?
Judge, I'm happy to answer that question. I'm actually the public defender assigned to Judge Levy's courtroom. I'd have to appear in court and ask the judge to sign a transfer order to Judge Lerner Wren. I'd ask for pretrial because for that process to happen, Mr. Atteni will be sitting until I can go into court and get his case transferred to Judge Lerner Wren.
You can actually transfer it here.
What was that?
We could the clerk has an order. We can transfer it to Judge Warner Wren this morning.
Yeah, I'm gonna do it.
And is Mr. Brown or Mr. Etienne?
Brown.
Oh, because he said Etienne, I just wrote
He did, it's Mr. Brown.
Okay, just want to make sure.
Okay. Transfer to Wren.
Okay.
Thank you. Renell Enton.
Yes.
You're charged with trespassing, bond is set in the amount of $25. I find probable cause. You want to plead no contest?
Yes,
You-
Judge, he does.
You understand, sir? You have a right to go to trial, make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right to cross-examine all the witnesses, the right to call witnesses your own, the right to put on a defense, the right to have an attorney. And if you're not a citizen of the United States, this could subject you to deportation. And if you enter a plea, you're waiving those rights. Are you doing that freely and voluntarily? Nobody's making you do it?
No, sir.
Okay, time served. Have a good day. No return to that property. DeAndre King, I'm sorry. Mr. King, you're charged with, got a capias, $100 fine probable cause. Yeah, it's for driving without a valid driver's license. Do you want to plead no contest?
Judge, accepting that
Yes,
plea,
Judge.
Judge, I just
Resolved.
need to go back on the record, accepting that plea. The last gentleman's case, he has
Counsel,
been-
between the noise and the rest of it, I can't hear
I'm
you.
sorry. That gentleman is represented by the public defender's office, the previous gentleman. I'm sorry to go back, but it's important. Renell Etienne, he's currently in drug court. And he's been sentenced to probation drug court. I don't know if accepting that plea will violate his probation or not. Ryan?
No, I don't see it would be because if he's, okay. We need the prior gentleman if we can have him.
Judge?
All right, we're all right, we're all right. On this one, do you want to plead no contest?
Judge, Mr. King has indicated that he previously resolved this case or was an issue with the name in the case. So I'd ask for him
All
to
right,
be
court will,
ROR pretrial.
the court will ROR him.
Thank you, Judge.
This is on King,
Yes, Judge, Mr. King.
right?
Yes.
Are we on
Judge, Judge,
DeAndre King, right?
yes.
Yes, Judge.
Okay.
Are you
Uh,
vacating the capias?
Yes.
I'm sorry, what?
Are you vacating the capias?
No, because it was already served. He said he's ROR.
ROR. Because it's $100 capias. Capias served, he's in jail. Ordonez Lopez.
Mr. Lopez bonded, Judge.
What's that?
He bonded.
Oh,
We
okay.
just need a finding of PC.
Okay, then we got Samuel Renshaw.
Yes, Judge, main jail.
All right, you're charged with trespassing, bond is set in the amount of $100, and you got a capias, $25. A special PD has been appointed in this case on the municipal ordinance. Bond is set $125. Have a good day.
Thank you, Judge.
Thank you. Kenneth Zachary.
Yes, sir, Your Honor. North Brown, John. Yes, sir, how you doing, Your Honor?
Mr. Zachary, this is an ad charge. Petty theft, bond is set in the amount of $750 because it is a third or subsequent offense. That means that it's a third-degree felony. Court finds probable cause, bond is $750.
Your Honor, I spoke to Mr. Zachary this morning. To be blunt with the court, he has no bond holds on counts 2 through 6. He did ask me that if he does resolve those, that he tells me he'd be unable to afford $750. I'd ask Your Honor if you would consider making it $100. He's going to be held no bond regardless.
He's already hold no bond.
He asked
No,
me
no,
to
I'm
ask,
coming.
so-
$750. Have a good day. Lucas Garcia.
Yes, Judge, main jail.
Mr. Garcia is charged with an ad charge of intimidation and threatening a witness or individual. This is an ad charge, counsel?
Yes, Judge.
Okay. And do you wish to be heard on bond?
We would ask for a $5,000 bond, Judge.
5?
Yes, the issue.
Okay, I understand. Defense, anything?
Judge, Mr. Garcia would not be able to afford even a minimal bond in this case.
Okay. The court finds probable cause on the ad charge. The court orders no contact. That means no contact directly, indirectly, in any way. If he's able to bond out, he will surrender any firearms that he has. Court sets bond the amount of $5,000. Okay, Marcus Clervin,
Yes, Judge.
charged, sir, with robbery, wearing a mask while committing a second-degree felony, and a violation of probation. There's a no bond hold on the violation of probation. Court finds probable cause as to all counts. State, anything on counts 1 and 2?
Yes, Judge. Judge, the state would be asking for a no bond hold on count 1. It is a punishable by life offense. In this particular instance, the state would argue that there is proof evident, presumption great, based on the probable cause affidavit, which the courts have held in Esaza.
Yeah, the court's read it. The problem is, there is an ID issue.
Well, Judge, there are
They
two-
were wearing masks, and you're going on proximity of time and being stopped, et cetera, not the ability of the person who was robbed.
Judge, there's also a co-defendant in this case who's next on the docket who makes an admission and admits that he was the driver of the vehicle and places himself.
Yeah, but I think they were all caught in the vehicle.
in
Right?
an admission that they were involved in the robbery, Judge, at the McDonald's.
Okay. Well,
On Mr. Oriole Napoleon, he makes a statement, Your Honor. Additionally, Judge, I mean, they were chasing.
yeah, but the problem with you have with that is, again, when you ask for me to find on a probable cause, that as to Clervin, he's the passenger.
No, Judge, Marcus is correct. He's in the front seat.
He's in the passenger seat.
Correct, Judge.
This is pull up to the drive-through window.
Yes, Judge, but they were all
And,
wearing.
and the man in the driver's seat who gave the statement said he was driving, he had the gun, and he did the talking.
Yes, Judge, but I would also point out that the occupants were all wearing black hoodies. They had firearms in the same vehicle. They're all coming from the same location.
They don't-
They're all co-defendants. They're all principals.
Well, I understand they're all co-defendants and principal, but what is the rule?
Well, for purposes.
Presumption great,
Yes, Judge.
okay? I think I understand as to Mr. Napoleon,
Yes, Judge.
okay, as to Mr.
I do have.
And I believe, and I mean, maybe I've read it wrong, and please correct me, as to Mr. Clervin, Marcus Clervin, he's wearing a hoodie.
Correct. He has a black
He's-
hoodie as well. They were wearing masks.
I read hoodie. Let me double check.
I could maybe simplify that discussion, Your Honor, if we're speaking about count 2 in particular. I would argue there's no PC.
What's that?
I would actually argue there's no PC to count 2. The reason why is if you actually look at the statute, what the statute.
Counsel, we're on one subject.
Oh,
Stay with
well, I know
one
you're
at a
talking about
time.
The hoodie, I thought that was
Okay.
to the mask, allegedly.
Arguably, Judge, the mask, would be a principal with Mr. Napoleon.
Well,
So, if Mr. Napoleon is seen wearing a mask, and he's. the
if
one that-
Mr. Napoleon and if Mr. Napoleon had a mask on and Mr. Clervin didn't, there may be an issue there. That's what I'm talking about. If Mr. Clervin has the mask on also, I agree with you. So I'm reading this, and when they're writing the probable cause affidavit, most of what they are talking about is they are talking about Mr. Napoleon, even though it's in Mr. Clervin's PC. You reading it with me?
Yes,
You
I am.
following? Because it says the subject vehicle refused to stop, chase ensued.
Judge, it says in this
Okay,
instance here,
the
victim
front,
stated-
wait a minute, but listen to this. The front seat passenger was immediately taken into custody inside the vehicle. He never left the vehicle.
No, Judge.
The other guy's running, the other guy's taking off.
However, Judge, the victim, in the probable cause affidavit states, the victim stated both occupants of the vehicle were wearing black hoodies with black masks. So the witness in this
The
case.
victim prayed, but that wasn't seen. I don't know. Okay.
I mean, this victim or this witness, Judge, was working the drive-through window. That person would have a best view in this instance.
I mean, I'm just, okay. As to Mr. Clervin,
Yes, Judge.
the court finds probable cause. The court orders,
As far, I just want to also read his priors for you, Judge.
the what?
His priors.
Yep, go.
He does have a 2014 robbery by sudden snatching that did resolve with an adjudication and 4 years probation.
Okay.
That resolved in 2018.
Right, and he's got a no bond hold for that probation too.
Correct. That was resolved
Okay.
in March of this year.
All right. But I'm setting the bond on Mr. Cleveland in the amount of $50,000 on count one and $25,000 on count two, based upon the statement in the affidavit that somebody saw him wearing a mask.
And Judge, for the record, we just need you to, just to state that you're not finding proof evident presumption grade.
I'm not finding proof evident presumption great at this time, because I believe it's premature.
Hold on.
Your Honor, when it
Judge,
comes to count two, I would have to object to probable cause. I don't know if it's the wrong statute that's before us, but looking at the statute, what he's being charged with here, it's an aggravator. What it speaks to is that if it happens during a misdemeanor, it becomes a felony. If it happens from a third-degree felony, it becomes a second. If it's a second, it becomes a first. The problem is that this is a first-degree felony. The statute's completely silent to it because you can't aggravate beyond that. And so I don't actually believe this charge is the correct charge here. There might be a different statute number, but this is the wrong one, that this is an aggravator. The state says this is a first-degree punishable by life. There's nothing to aggravate it to.
Counsel, your objection is noted.
And
on-
Judge, if I may add, Mr. Clervin in no way can afford the 10% of $7,500. If Your Honor is willing to reduce that,
Fine, he's got a no
is going
bond,
nowhere.
he's got a no bond hold violation of probation, counsel.
I understand, Judge, but if that does resolve at some point, he'll have a bond sitting that he just absolutely cannot pay.
Okay, and I'll leave that to the judge to whom the case is assigned.
Understood, Judge. Thank you,
Okay,
Judge.
thank you. All right, on Arnold Napoleon.
Yes, Judge.
You're charged, sir, with robbery of firearm, no bond, resisting a real officer without violence, $100 bond, wearing a mask while committing a second-degree felony, no bond, fleeing is no bond required, robbery by sudden snatching, no bond is set at this point, and then wearing a mask while committing a second-degree felony. Isn't that two of them?
Yes, Judge, this is the co-defendant.
I thought Mr. Napoleon was the driver.
Yes, Judge, Mr. Napoleon is the driver. I'm sorry, maybe I misunderstood your question.
Where do you get the second offense? How many people were robbed? I've got Count one, I don't have any problem with. Count two, I don't have any
Well,
problem
no,
with.
Judge,
Count
the way
three,
it is-
count four, I don't have any problem with.
Right, Judge, they're separating two instances. It states here in the probable cause affidavit that the defendant brandished a small handgun.
Right, I've got that. And then I also have,
Then it says the victim grabbed cash from the register, handed to the suspect. That's one charge.
okay, so you're saying that when then he grabbed money, so you're saying that's a separate count?
Yeah, it says there appeared to be more cash in the drawer, which the suspect observed. He placed his finger on the trigger.
Right, I got that, I read it.
And then got a second
Wad of
handing
money.
of money. Yes, Judge.
Okay, I've got that. But where do we come in with adding the mask again?
Well, I guess because both of those felonies were committed while wearing a mask, Judge, so it's another.
But that's the start of the whole thing, aren't they? Don't they merge?
No, Judge, they're separate and apart. It would be the same thing as if someone struck someone with punched them as a battery, and then they punched him again. That's
Okay,
technically
but
two
you could also argue that the robbery and then the grabbing the thing was all in the same transaction.
Well, Judge, I would argue that's a great grounds for maybe motion to dismiss at some point, but right now we're just talking about probable cause and whether.
Okay,
there's probable
all right.
And
On
obviously-
count one, on all counts, the court files probable cause. On count one, it's no bond. The court finds the evidence is great, the presumption. On the resisting, it's $100 bond. On wearing a mask while committing a second-degree felony, the bond is set in the amount of $25,000. On fleeing, state, you want to be heard on bond on that?
Judge, I would be asking for a $10,000 bond.
Defense?
Judge, Mr. Napoleon is not going to be able to afford a
I
$10,000.
understand that argument. $10,000 bond, I believe, is reasonable. On the robbery, sudden snatch, I think I'm going to leave no bond on that. And on wearing a mask, on the number 6 is ROR.
Actually, he's entitled to bond on count 5. Robbery by sudden snatch, it's not a PBL, so he.
Count 5?
Correct.
Okay. State, you want to be heard on the amount of bond on that?
Judge, I'd be asking for a $25,000 bond.
Okay.
The only issue with that, Your Honor, I understand the conversation between you and the state. I believe that's a separate case, and we just don't have the PC. On the PC, we all do have. It's written on the top of the second page, 2 PCs, even though we have 1. And on our docket, I know Your Honor doesn't have the docket, it listed as separate offenses. That the PC we have is offense number, it starts 04. Counts 5 and 6 for an offense that starts 10. So I'm thinking there's a separate case.
Oh.
And so I understand the argument you and the state were having, but I
I don't think the state can file a second case.
well, I think it might have been a separate PC that happened either before this and.
I don't know. They're talking about snatch, and I read that in there. I'm going to set bond the amount of $10,000 on that, because there's a no bond, and anyway.
The only thing I'm asking for is the photo order I see is.
Okay, have a good, we're done. Lamont Green. Lamont Green, you're charged with
Yes, Judge.
tampering with physical evidence, municipal ordinance violation, and an ordinance violation. I find no probable cause on count 1.
Judge, if I could just have 1 moment.
Excuse me?
If I could just have a moment in regards
You
to
may.
the argument. Judge, in this case, the defendant was advised that he was being detained for a beverage violation, and when the officer went to retrieve the plastic cups from his trunk, that's when the defendant tried to conceal the beverage that he was observed holding by putting it behind the trash can. So, Your Honor, I would argue that there is probable cause that he was interrupting an investigation.
That's not how I read it, Your Honor. My understanding of reading it, the officer was at the scene, and upon seeing the officer, that's when the alleged actions happened, and the officer had not actually announced himself yet or actually begun to conduct the stop yet.
Okay.
Well, Judge, I would argue that
All he did was, he saw the police officer, walked over and put his beer can down next to the trash receptacle, I think.
yes, Judge. I mean, I'm not disputing the complexity of the case, but the defendant is seen making visual contact with the officer, and then putting the beverage behind the can.
So every time.
No, he put the beverage, turns around and it says, place the beer can on the sidewalk next to it.
Judge, was he free to go?
He went
prior
up,
to
in
that?
other words, he went up to the trash can and put in a thing. Put it in the trash can. Or put it next to the trash can. Come on.
It's next to the trash can, Judge. If I could,
Court
Judge-
finds no probable cause. ROR's the defendant.
Thank you, Judge.
All right, he's done. Do you want time to perfect, gentlemen?
If he's ROR, they can file however they're gonna file it.
It's fine, Judge.
Thank you.
Joseph, or Paul Joseph Johnson.
Yes, Judge.
Okay, you're charged with burglary of an occupied dwelling and violation of probation. Count 2, no bond hold, violation of probation, no bond hold. State as to count 1.
Yes, Judge. Based on the defendant's criminal history, Judge, I would be asking for a $25,000 bond. I'm showing in 2007, or in 2018, in April, he resolved a burglary of a conveyance to an adjudication, 2 years probation, and a grand theft. Additionally, Your Honor, he resolved a separate case, possession
Okay.
of cannabis more than 20 grams.
Defense, anything?
Actually, just so it's clear, Your Honor, I have no objection to second-degree felony burglary being found. The problem is actually charged this as a first-degree, saying it happened during a state of emergency. I would ask Your Honor not to find PC to that, because that's not the case. I have no objection if Your Honor finds.
I thought that was a typo.
Well, before us this morning, it's a first-degree felony, and I would ask.
Well,
Your
no,
Honor
no,
to-
no, I thought it was, I looked at it as a second degree.
No,
I thought that's a typo on just the charging I mean, not,
I agree
the
with
charging
the typo.
I mean, on the front of the PC sheet.
Right, so I'm just asking Your Honor to fix it. I believe it might have been a typo, so we just need to fix it this morning.
Because on the typed PC affidavit, it says burglary dwelling, unoccupied, unarmed.
SOE, state of emergency.
So,
It's how the officer charged, because if you look at the face sheet also, the officer, when he keyed in the statute number, he keyed in to make it a first degree, so I would just ask Your Honor to find probable cause to second degree.
state,
For a burglary dwelling, lesser offense, Judge, that's fine.
okay.
Second degree.
I find probable cause as to burglary of a dwelling. Okay. And I'm going to set bond, the amount of $25,000. Okay, because the violation of probation or no bond holds. Okay. Then we've got Carlos Pantalone.
Judge, on Paul Johnson, if I could just ask for a no return and no victim contact.
No victim contact. No return to the property. Okay, Pantalone, you're charged with driving under the influence, $500 bond, driving under the influence with property damage, $1,000 bond, probation violation, no bond hold. The felony is a felony VOP. You'll be detained going before Judge Bailey. Court finds probable cause. Edward Thompson, charged with possession of cocaine, municipal ordinance violation, count 2, and tampering with evidence. Bonds are set in the amount of $1,000, $25, and $1,000. Any prior state?
Judge, on Mr. Thompson, I'm showing 2003 loitering and prowling,
Okay. Do you have anything major?
just drug offenses back in the 90s.
Okay, pretrial release.
Thank you, Judge.
Yep. Warren Atkin,
Yes, Judge, main jail.
you have violation of probation, no bond hold. You'll be detained going before Judge McCarthy. 23rd.
Thank you, Judge.
Okay. Trevon Watson. Trevon Watson, you're charged with, you got your microphone off. You can hear me
It's on,
now?
Judge.
Okay.
Yes, Judge.
You've got an aggravated assault with a deadly weapon without intent to kill. You've got burglary of a structure or conveyance armed, and you have possession of burglary tools, which is $1,000 bond, and resisting an officer without violence, $100 bond. What say you states as to counts 1 and 2?
Judge, the state would be requesting a no bond hold that Your Honor would find proof evident, presumption great as a punishable by life offense. So I would be requesting no bond, Judge.
When it comes to count 2, to hold Mr. Watson no bond, Your Honor would have to find proof evident presumption great. As we discussed this morning in the 4th DCA, that's actually beyond a reasonable doubt standard. My biggest concern reading the probable cause affidavit, unless I'm missing it, there was never actually a show-up done. That there was a call that they were looking for individuals in an orange sweatshirt. At some point, Mr. Watson and I believe Mr. Watt, who's the next individual, were apprehended. And because one of them was wearing the orange sweatshirt, we don't know exactly how far away they were from the scene. They don't tell us that in the probable cause affidavit. But what's more concerning to me is that there's no show-up. They have a victim, that they spoke to the victim, but they don't have the victim identify either Mr. Watson or Mr. Watt. And so the only thing that actually ties both these individuals, more importantly right this moment, Mr. Watson, to the crime is that there was an orange sweatshirt.
Well, he was close enough to shoot at him.
In addition, Judge, these defendants were under surveillance by the officers
Right.
as well.
They also were observed doing it by the owner of the property.
But there's no, from my understanding, I don't see anywhere in the PC where they brought these individuals back to that owner, and the owner said, yes, that's them, that I don't see any.
I understand what you're saying, but the problem is, I think in the process, it's clear that he said they were the people. Now,
But where? Where does it say?
well, I understand that, but, okay. The court at this time has no bond on count 1, count 2, no bond, the proof evident presumption great, and the bonds of 1,100 on 3 and 4.
He is entitled to bond on count 1 regardless, that's not a PBL.
Excuse me?
For count 1, he is entitled to bond, that's not a PBL.
Is that correct, State?
Correct, Judge. Count 1.
Okay, bond is set the amount of $20,000. Tony Amon Lot.
Co-defendant to Mr. Watson, Your Honor.
Okay. Mr. Lott, you're charged with aggravated assault with a deadly weapon without intent. Court finds probable cause. Burglary of a conveyance armed. The court finds probable cause. Grand theft, $1,000 bond. Possession of a weapon and ammo by a convicted felon. I find probable cause and resisting police officer without violence. Count one, $20,000 bond. Count two, no bond. Hold. Count three, $1,000. Count four, $5,000 bond. Count six is $100 bond.
And Judge, for the record, are you making a finding of proof evidence?
Yes.
Presumption? Great, thank you.
And again, Your Honor, I would object that the only thing that, according to the PC, that ties Mr. Watt to the scene is the orange sweatshirt. I understand Your Honor might like to believe that a show-up was done, but they don't actually say it in the probable cause.
I understand that. Have a good day. Russell Frazier,
Your Honor,
and
I'm
so
sorry.
noted for the record.
This is a correction for that. There's another charge, account 6, that was left off the booking sheet.
On lot?
Yes, sir.
There was, right, an added charge, Judge, I just got the PC as well. Possession of burglary tools with intent to use, it has $1,000 standard bond. Just need a finding of probable cause, Judge.
Okay, court finds probable cause, sets bond the amount of $1,000 on the last count. Russell Frazier. You're charged with aggravated assault with a deadly weapon without intent to kill, burglary of an occupied conveyance unarmed, and petty theft. Okay, state.
Judge, in this particular case, Mr. Frazier has a 2004 burglary of a structure unoccupied that he resolved. And
What are you asking in bond?
oh, well, Judge, as far as bond, Judge, I'll be asking for a $20,000 bond.
20,000?
Yes, Judge.
Okay. And what about count two?
Count two, Judge, 5,000.
Okay. All right. Court at this time finds probable cause as to counts 1, 2, and 3. The court sets bond in the amount of $20,000 on count 1, $5,000 on count 2, $100 on count 3. Court finds said probable cause all counts. Larry Brown.
Judge, real quick on Russell Frazier, requesting no victim contact as part of.
Well, no victim contact, okay. Mr. Brown, you're charged with a felony violation. You have no bond hold. You'll be detained going before Judge Shearer.
Thank you, Judge.
Okay, Terrell McRae. You're charged with possession of a scheduled, I can't read this, it looks like a,
I think it says counterfeit, Judge.
okay. Substance, $1,000 bond, distribution or delivery of heroin, $2,500 bond, possession of cannabis, $100 bond. Court finds probable cause, all counts. Okay. Turner, okay, Perry Turner. You're charged with possession with intent to deliver cocaine, $2,500 bond, distribution and deliver cocaine, $2,500 bond, paraphernalia, $100 bond. Court finds probable cause, all counts. Ronald Smith.
Judge, Mr. Turner is a veteran. I'd ask if you could do a transfer order to Judge Merrigan in Vets Court.
What's that?
We don't transfer to Veterans Court from magistrate. It needs to go to the division.
He said we don't transfer from Veterans Court to Veterans Court from magistrate. He has to go to the regular court and then be transferred over.
Okay, understood. So then mental health court must be an exclusion to that rule. Thank you, Judge.
Okay, thank you. I think they both ought to be, but you know, that's.
I agree, Judge. And Judge, Mr. Turner absolutely cannot afford that bond even close. If Your Honor's willing to reduce it, there is a chance he'd be able to afford something that is in the $1,000 per count range.
Judge State's position would be based on the circumstances, and I think that he has a prior history, Your Honor, uttering a forged instrument and grand theft that was resolved in 2017. Before that, 2016, he had a felony battery. And in this particular instance, the defendant stating that he sells drugs. Second-degree felony.
And Judge, Mr. Turner has indicated that he has not failed to appear for court.
Counsel, the court sets bond $1,000 count one, 1,000 count two on the drug paraphernalia. The court RORs. Have a good day.
Thank you, Judge.
Ronald Smith. Mr. Smith, you have a violation of probation. Find probable cause. No bond hold. This is out of another county. The possession of cocaine, $1,000 bond. Possession of paraphernalia, no bond required. You need a $1,000 bond, plus you need to deal with the hold from out of county. Have a good day. Charles Tanner. You're charged with driving with a suspended driver's license, no bond required, reckless driving, no bond required, fleeing and attempting to elude law enforcement officer, $1,000 bond, and you got a violation of probation, which is a felony violation. You'll no bond. You'll be detained before Judge Wood.
Thank you, Judge.
Thank you. Gregory Johnson. You're charged with possession with intent to deliver cocaine, $2,500 bond. You got a traffic violation, no bond required. Then you got 2 violations of probation. Both of them are felonies. Both of them are no bond holds. And you'd be going before Judge Porth. Then we got Mr. Pinto Molina.
Medical research, Your Honor.
Richard Cunningham.
Judge, this was requested to be rolled over to tomorrow so that the affidavit for the arrest warrant can be unsealed from Judge Lynch.
Okay, Mr. Cunningham?
Mr. Cunningham is who he just addressed, where he had to be reset. This is Mr. Max Arvin Saintville.
Okay, Mr. Cunningham had to be reset. Who's the gentleman standing next to you?
This is Mr. Max Saintville, page 26.
Okay. And Mr. Cunningham is not present.
That's correct, Judge.
Okay, so it's reset.
Yes, Judge.
Thank you. I did that one.
He was reset.
They said
Okay,
reset.
I just want to make sure.
Max St. DeVille,
Yes. Main jail.
you're charged with unlawful possession of another person's ID, $100 bond, unlawful possession of another person's ID, $1,000 bond, fraud, $1,000 bond, unlawful possession of an ID, $100 bond, fraud, $1,000 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 bond, possession of cannabis, $100 bond, possession of fentanyl, $1,000 bond, possession of paraphernalia, $100 bond, and driving while license suspended, $100 bond. Court finds probable cause, all counts.
Your Honor, when it comes
Judge?
to Mr. St. Bill, this is an issue that comes up quite often with how the officers do this. What the statute says, I have it in front of me, and you can even see by the way they charge it a little strange here. How it says in count 1, they charge him with having 4 or less, and then count 2, they charge him 5 or more. What the statute says, if it's 4 or less, it's a misdemeanor. If it's 5 or more, it's a felony. Well, so it doesn't matter if he has 5, 6, 7, it doesn't matter if he has 20, it's 5 or more. It should be one felony charge, not a felony
For every 5?
charge. No. As the statute reads, it says 5 or more. And so it doesn't matter how many more than 5, it should be arguably on how the statute's written plainly. A person who violates a section and doing so possesses the personal identification of 5 or more persons commits a felony of the 3rd degree, not a felony for every single one. Additionally, what concerned me in the probable cause, we actually don't even have the number. The officer writes numerous credit cards. Even if I give the officer the benefit of the doubt that it's 5 or more, I definitely don't know if it's upwards of 12 that the officer writes all these charges for, because he actually doesn't enumerate how many. But it is my belief, reading on the statute, the language is clear, 5 or more. Anything more than 5, it's one charge, not 11 different charges.
State.
Judge Aaron passing on behalf of the state, the state exclusively holds the right to charge the counts as it sees fit, and in addition to that, the officer states that there's hundreds of pieces of mail.
Okay. The state position is what?
We disagree with counselor's argument.
Does the statute say that? What counsel says?
What counsel represented as far as the words of the statute, yes, but his interpretation of it, we disagree with.
Oh, the words of it. Okay. Do you have a case law that states different than?
If we can have a moment to step back and put this on recall, I can provide your honor with any case.
I'll put it on recall. No problem.
Thank you.
Because the words of the statutes are kind of important, you know. Rhett? Andrea Rhett? Okay. The grand theft, $1,000 bond, violation of probation.
Excuse me, Judge. Andrea Rhett is on medical loan. And reset, please.
Okay, medical. Reset.
Thank you, Judge.
Tony Mims.
Yes, Mr. Mims is to my left, Judge.
Okay. Mr. Mims, you're charged with possession of cocaine, $1,000 bond. You've got a misdemeanor capias for petty theft. Bond is $500, so you have $1,500 in bond. Noah Tylo. You have possession of methamphetamine, $1,000 bond. No bonds are required on the other charges. I find probable cause. Bond is set in the amount of $1,000. Any priors?
Just one moment, Your Honor.
Hmm?
Just briefly, 1 minute, Your Honor. I am not showing any priors, Judge.
Judge Terry Townsend, pretrial services, he does have a prior arrest in New York for criminal sale of a controlled substance. He was adjudicated. In addition, it appears that the defendant has a possible warrant out of Miami-Dade.
But a possible.
Right, for no valid driver's license.
Oh, okay.
And also
Judge, I'd ask for pretrial.
2014
What's that?
2014 drug possession adjudication withheld.
Okay.
And
Pretrial.
ask for pretrial for Mr. Tyler.
Pretrial. Yes. Baron Howard,
Yes, Judge.
you've got capious, $1,000 bond and violation of probation, of felony, no bond hold. You'll be detained going before Judge Uson.
Thank you, Judge.
Okay. James Arlington,
Your Honor, I'm sorry, on Mr. Howard, I'm in the process of checking his probation. It shows on a court order that if he paid his $70 fee, then his probation is terminated at that time. I don't have anything to say or being able to whether until Monday.
all right. But that's all he had to do.
That's what it said, yes.
Yeah, so we'd be spending more money to keep him in here than we'd be getting.
Arguably, Judge, depending on the length of his probation, if he just has to pay, then it would early terminate. I don't know the conditions of what that $70 is for.
That's usually cost of supervision.
I don't know if it's cost of supervision or if it's restitution or anything like that. A lot of times probation is ordered and then restitution needs probation to enforce
I
it.
understand that.
Excuse me, Judge. Mr. Arrington is represented by private counsel Bradford Cohen.
Well, that means I can't do anything anyway. Okay, sir, you need to post $1,000 bond if you have the other proof.
Judge, are we talking about Mr. Arrington?
No, Mr. Howard.
Oh, okay, I'm sorry.
That's who she was talking to me about.
And there's just a copy of that order.
Huh?
There's just a copy of it.
Okay, this is a cost of probation.
Understood.
Okay. Okay, on the count one, I'm going to ROR him, and on count two, I'm going to,
Judge, it is a violation of probation on a felony offense. He is not entitled to a bond.
okay. I don't know that it's a violation of probation. But you're right, the probation still is in effect until the $70 is paid. Okay. You understand, Mr. Howard? You got $70 to pay probation. Get somebody to pay probation the $70 and you're out.
Judge, if we could just have one moment here. There was some confusion when Mr. Howard.
That's not Mr. Howard standing there is the issue.
No, that's not Mr. Howard.
No, Judge, it's not there.
They can't hear when pretrial was speaking, if I was speaking, there's not a microphone over there.
Okay, Mr. Howard.
Present, Judge.
Okay, Mr. Howard, I'm gonna ROR you on the capious. But you've got a violation of probation with a no bond hold. All you have to do is pay $70 to terminate that probation.
Understood, Judge. Thank you, Judge.
Thank you. Okay. I can't change the bond on the VOP.
Judge, if we could recall Mr. Arrington at some point.
No, let me
He's on
get, I'm gonna get Mr. Arrington, yes.
He's on it. If we may recall him, please, Judge?
I've got Arrington right here.
Yes, Judge, I understand. May we recall Mr. Arrington is not present at this moment.
Okay,
Thank you, Judge.
thank you. Cedric Ware. Mr. Ware, how old are you?
Judge, 22, Judge.
You're charged with grand theft. I find probable cause. Bond is set in the amount of $1,000. You got trespass on school grounds. No bond is required.
Judge, I'd ask for a pretrial, please.
Granted, but no return. No return to Cross Creek Elementary School.
Understood, Judge. Thank you, Judge.
Delroy Renton. Correct. Mr. Renton, you're charged with possession of cannabis with intent to deliver $1,000 and not wearing a seatbelt. I find probable cause. Okay. I'll praise Mr. Renton on pretrial.
Thank you, Judge.
George McKinney. You're charged with possession of cannabis, $100 bond, possession of cocaine, $1,000 bond, possession of Oxycontin, $1,000 bond, tampering with physical evidence, $1,000 bond. Court finds probable cause.
Judge, Mr. McKinney said that he could afford about $200 if Your Honor is willing to make the aggregate amount of the bonds sufficient so he may make the payment to the surety.
Okay. State. All right, on count one.
I'm not showing any priors, Your Honor.
Okay. On count one, I'm going to ROR him. Count two, I'm going to $1,000. Count three is $1,000. And count four, I'll ROR.
Thank you, Judge.
Okay. Wendy Pierre Lewis.
Medical reset, Your Honor.
Good, I couldn't figure it out. I got it.
I was briefed on that.
Robert Allen.
Yes, Judge, main jail. Mr. Allen is present to my left.
Okay, we have violation of probation, felony, no bond hold. You'll be detained going before Judge Rothschild.
Thank you, Judge.
Thank you. And then we have Dante Bailey.
Yes, Judge.
This is an ad charge. Change of charge to robbery with a firearm.
Yes, Judge.
Okay. Okay, it's a change of charge from robbery with a weapon to
Right.
robbery with a firearm.
Right now, yeah, it's robbery with a firearm or deadly weapon.
Okay. State, you want to be heard on bond?
Judge, I would be asking for a no bond hold, making a finding of proof evidence presumption great, Your Honor. It is a punishable by life sentence.
What I would tell Your Honor, so this is not the first time it's coming through. It came through as a robbery with a weapon. In the alleged weapons, a knife. The facts, as far as I know, have not changed. Just so we all are clear, he does have a no bond hold regardless, no matter what happens today. But when it came through originally on the same facts, the judge there found probable cause, did not find proof evidence presumption great, and set bond at $50,000. I would ask Your Honor just to do the same thing. The facts haven't changed. The only thing that changed.
Okay. Well, I have a problem. I have nothing other than the warrant. But State, I will set bond at 50,000 unless you,
I'm looking at the original probable cause affidavit. The first time it came through, I see it was also 50,000, Judge, so.
okay.
Just-
$50,000 bond,
Right, and Judge, the additional terms were no victim contact,
no victim contact,
no return.
no weapons, no firearms, and,
And no return.
okay.
Understood on all conditions, Judge.
All righty, thank you. Now we're back to Saintville.
Yes, Judge,
Yes, Your Honor.
statute now, I wanna make sure I understand Counselor's argument.
What's that?
Printing out the statute now, I just wanna make sure I understood Counselor's argument. You're arguing that.
His argument is that if you have more than 5 of them, it's not individual charges, it gets lumped into one. And it's a third-degree felony.
Because the statute reads, a person who violates subsection 2 and doing so possesses personal identification of 5 or more persons commits a felony of the third degree. So anything more than 5 is what makes it a felony, where if it's 4 or less, in this case, or not. It's going to be subsection 3B2.
Okay, because the
It
statute.
would have to be the statute that's 90 pages long. What is the section and subsection?
The state's charging under 2A, which states that any person who willfully and lawfully without. But that is,
Okay,
but that is the subsection that was stated.
What's on the page sheet today is 817-5685-2.
how many priors does this gentleman have?
I'll look now,
My
Your Honor.
co-counsel's looking that up, Judge. In the meantime, I'm gonna pull the,
Huh?
my co-counsel is looking that up. In the meantime, I'm gonna pull the statute 5685.
And where are you looking?
So this is the wrong statute that he provided.
This is a different
This is
statute.
different from what the.
Okay. But that's the statute
So,
they're citing here.
no, I'm printing out the one that counsel is referring to right now, Judge.
Well, no, but what I'm trying to say is that the statute that is cited in the probable cause affidavit is this statute.
They take both, actually.
Right.
But I'm looking at it.
So if I were to charge a judge, I would have charged under that statute, because that statute allows for the charging of every single individual identification under 2A.
Why is 10?
So now I'm approaching with 817-5685, which is what's stated on the bottom of the PC. Judge, may I approach?
Yeah.
Where counsel pointed out that there's a subsection here, 3A, which now deals with a person who violates subsection 2, and in doing so possesses the personal identification information
Okay.
for a few persons, commits a misdemeanor in the first degree, punishable as provided. Judge, in this,
I believe this is the state's call.
correct.
Okay.
Which was
I think you raised an interesting argument, counsel, but it's the state's call. My question is this. We've got, what is it?
We got about 15.
We got about $10,000, almost $11,000 in bond. What is his priors
You
like?
asked about a prior criminal history, Your Honor. I am showing that he currently has pending case number 170104771 CF10A, and that is 5 counts of burglary of a dwelling unoccupied.
Okay,
Your Honor.
counts, the court finds probable cause as to all counts. The bonds will remain in the amounts the court already put on record. Huh? Want me to go through it again?
Yes, I don't have the ones.
Okay. Count one, $100. Count two, $1,000. Count three, $1,000. Count four, $100. Count five, $1,000. Count six, $1,000. Count seven, $1,000. Count eight, $1,000. Count nine, $1,000. Count 10, $1,000. Count 11, $1,000. Count 12, $100. Count 13, $1,000. Count 14, $100. Count 15, $100.
And I would
Thank
just-
you.
I would just ask for no victim contact, Your Honor, on any of those.
No victim contact, although I don't think he even knows the victims with what he had. Okay, Arlington, are we doing anything with that?
Mr. Arrington is represented by private counsel Bradford Cohen, Your Honor.
Okay. The issue is, we have the home invasion with a firearm or deadly weapon. State, what say you as to bond on that?
Judge, count one is a punishable by life offense. I'm going to be asking no bond, and that Your Honor find proof evident presumption great based on the probable cause affidavit in this case.
And, Your Honor, since he's indicating that he does have private counsel, he is entitled to have his counsel present. He would be prejudicing no one but himself if he asked to have this reset.
I can reset it to tomorrow and somebody can notify his counsel.
Can you ask him if he wants us to have reset to get his private counsel here, or does he want to proceed today?
Sir, do you want me to reset this for your attorney to be here tomorrow? You got your microphone off, can I? It's an easy one, yes or no?
No? I'm having trouble. Yes, Judge.
Thank you, reset to tomorrow.
Excuse me,
Okay,
Judge?
Yes.
Judge, Mr. Arrington does not want to reset it anymore. He changed his mind.
okay, court finds probable causes to count one, no bond hold. Count two, $1,000 bond. Count three, $1,000 bond. Possession of a weapon by a convicted felon, $5,000 bond. False imprisonment adult, $5,000 bond. And, court finds proof evident and great.
And Judge,
Something great,
in an
okay.
abundance of caution, no victim contact. And
No victim contact, if he gets out, surrender all weapons. Okay,
Judge, is it very possible to do a no victim contact on Marcus Clervin? This was the instance in which the court found a no proof evident presumption rate on the co-defendant. We would just ask that in an abundance of caution. If this
well, there'd be
gentleman is
no
set free,
contact with the victim, I don't have a
We just
problem
don't
with
want
that.
to go back to McDonald's, his buddies.
No victim contact,
Thank you.
directly, indirectly, in any fashion. Okay,
Thank you, Your Honor.
thank you, I believe we're done. Sorry I was so slow today, gentlemen.